Well, hello. My name is Andrew Brown of Radcliffe Chambers, and I'm joined by the estimable Tina Kyriakides, barrister of Radcliffe Chambers, to speak about the recent case of BCB Environmental Management Limited in liquidation. This is intended as a brief chat about this case, which Tina appeared in, and by way of overview and background, what this case concerned was an attempt by proposed liquidators of 31 companies to restore those companies to the register, have themselves appointed as liquidators of those companies so that they might investigate the fees of the previous office holders. Now, with all of that being said, now is the time to turn to the actual important person in this video, Tina. And Tina, I suppose the first question I have about this is, restoration of companies is something that we usually do with junior barristers, of course, which Radcliffe Chambers provides competitive rates for. So what was it that drew a senior, experienced, highly skilled barrister such as yourself to this case?
Well, think about it, Andrew. With the case of a restoration, 31 restoration applications for 31 companies, we were opposing 29 of those. The reason they wanted to restore was that they thought they'd been excessive charging the fee. So just imagine it, if they succeeded, the real hassle. So my clients would have been, there would have been investigations, they would have had to go back through files of companies they thought they'd put to bed. So really the time and energy that would have taken. And also some of these restorations, some of these companies have been dissolved really quite a number of years ago. So, yeah, so that was the reason I was really brought in, was really just to try and put a stop to all of that.
Well, I suppose the next question I have is, of course, the Companies Act provides any number of grounds upon which someone might apply to restore a company. In this case, what exactly were the applicants as proposed new liquidators relying on to say that they could restore a company?
Yeah, so they were really relying on the sweep-up clause, which says any other person appearing to have an interest in the matter. So they didn't fall with any of the other specific categories.
Well, if they were relying on being persons of interest, well, forgive me for asking this question. Perhaps I should have known the answer anyway. But if they were saying that they were persons interested, is there any case law, any background saying that proposed liquidators could become or were an interested party?
No, this was the very, very first case on that. But it's interesting because even authorities under the current Section 1029, there's very little on that. Perhaps the only case is Barclays Bank against Sharma, but that wasn't a case where the court had to determine whether an applicant had locus to apply to restore. It was where a restoration order had been made and the former administrator was seeking to rescind it. And so what the court did there was just to really treat it as though it's an appeal against restoration by somebody affected by the order. So really, all the court had to fall back on was really the case law under the former provision, which was Section 651 of the Companies Act of 85, and really those predecessor sort of sections. And those cases are quite interesting because, again, nothing at all like the case we had to deal with. And really, they were all cases where the courts were saying, well, you have to have either a financial or proprietary interest in the restoration, or for it to be restored, it had to be to enable you to carry out your statutory duties. But really nothing like the present case. So if you have a look at what the court decided here, the court said, well, yes, those cases actually do provide some guidance. They really highlight factors that the court, which are relevant to the issue of standing. But what the court didn't want to do, if you actually have a look at the Act doesn't define the circumstances for that sweep-up clause. And so the court said, well, what we don't want to do is we don't want to limit, we don't want to close off the circumstances for applicants, because there might be cases outside of those parameters, and we really want to keep that open.
Interesting. Well, did the applicants have any success, or did you roundly defeat them at every turn?
Oh, we roundly defeated them. The court just said the court actually refused all of the applications. They said they were really just strangers. to the companies. They had produced various arguments. So, for example, HMRC, which was a creditor in all of the liquidators or administrations, were supporting the application. The court said, well, the supportive creditor cannot give you locus. Also, they've been appointed as liquidators of 3 companies, and bearing in mind those 3 companies were where there were office holders who were of the same firm as most of my clients, not all of them, had been partners or they were employed by. And so the court said, well, those 3, again, having been appointed as office holders of those, you don't need to be appointed as liquidators of this company. These companies don't need to be restored in order for you to carry out your duties. And they were also saying, well, but we want to do this because the whole purpose of this is to investigate these excessive charges. And the court said, please do not conflate purpose with standing. You don't have standing. The other thing that was perhaps quite interesting, and this was certainly a point that we were arguing a public policy issue, the court said that it thought it would also create an unhealthy precedent if it allowed them to restore these companies. I think what it didn't want to encourage IPs to do was really to trawl through, public records of companies that have been sold, just to see if they could find any potential case against an IP, and therefore then make applications to restore when really they had no interest in these companies.
Oh, that's quite interesting. Tina, just one last question. Thanks for sticking with us just a little bit longer. If HMRC is a creditor of these companies, or at least some of these companies, had applied for the restoration, would the position have been different?
Yeah, the position would have been different because certainly on the locus position, HMRC would have had locus as a creditor. So that argument is something that we could have relied on.
Well, great. Well, thank you very much, Tina, for giving us an insight into this case. It was quite fun. And I look forward to citing it in all of my future applications.
Thank you very much, Andrew.